Hello, Legal Eagles! I wanted to give you a quick legal update on the Abrego Garcia case because two extraordinary things happened since we released our fairly comprehensive video yesterday. In yesterday's video, which I'll leave a link to, we covered basically everything that happened from Mr. Abrego Garcia's erroneous deportation from Maryland to his extraordinary rendition to the CICOT gulag in El Salvador, literally the one country he couldn't be deported to. And we talked about how the district court judge is absolutely furious and has ordered expedited discovery. Specifically the depositions, meaning the questioning under oath of the government witnesses, some of whom are lawyers for the government, and how it looks like the judge is not going to entertain objections to privilege, even though these are lawyers because they were put forward as fact witnesses. Well, the latest government affiant, who previously filed a declaration under oath, apparently realizes he's in trouble and doesn't want to say more things that will get him into yet more trouble. Joseph Mazzara, acting general counsel for Homeland Security, filed a new status update with the court. And all it says is, I, Joseph N. Mazzara, declare under penalty of perjury as follows. 1. Please refer to my prior declarations for the foundation of my personal knowledge. Which is funny because, as we talked about, I'd argue those declarations do not establish personal knowledge in any way. And then he goes on to say, quote, 2, given the government's prior clear and unequivocal notice to the court regarding how the government will facilitate Abrego Garcia's return within the contours of existing law and regulation, there are no further updates. So yeah, they are really doubling down on the whole we're not going to do anything and you can pound sand approach. And the judge is not going to like that. But the second thing that happened is perhaps even more extraordinary. While all of this was going on, the government asked the Fourth Circuit Court of Appeals for a stay of the judge's order. But the Fourth Circuit moved lightning fast and denied the government's request, so things are proceeding in the district court. Judge Wilkinson wrote the order, and one of the extraordinary things about this order is the language that he used, but the other is the source. Judge Wilkinson is a Reagan appointee who tends to be maximally deferential to assertions of executive power. But Judge Wilkinson did not mince words. He says, quote, upon review of the government's motion, the court denies the motion for an emergency stay pending appeal and for a writ of mandamus. The relief the government is requesting is both extraordinary and premature. While we fully respect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. It is difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, there is nothing that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. That would allow sensitive diplomatic negotiations to be removed from public view. It would recognize as well that the facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. The Supreme Court's decision does not, however, allow the government to do essentially nothing. It requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Facilitate is an active verb. It requires that steps be taken, as the Supreme Court has made perfectly clear. Facilitation does not permit the admittedly erroneous deportation of an individual to the one country's prisons that the withholding order forbids, and further, to do so in disregard of a court order that the government not so subtly spurns. Facilitation does not sanction the abrogation of habeas corpus through the transfer of custody to foreign detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would reduce the rule of law to lawlessness and tarnish the very rules for which Americans of diverse views and persuasions have always stood. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment, we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we have noted, all too possible to see in this case an incipient crisis. But it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. I don't know, I thought that was worth flagging and updating yesterday's video. You know, given the author, this may have been written specifically for the members of the Supreme Court who are basically putting their heads in the sand to what the executive is currently doing. But it's also a sign that judges are taking this seriously. I realize if it's frustrating that if the Trump administration is going to be completely intransigent, it's going to take some time to force them to course correct. Still, given that the executive currently isn't stopping and is in fact scouring social media to punish speech it doesn't like, now might be a good time to scrub as much personal information from the internet as possible, which you can do with the help of today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. And you can use my link in the description or the code LegalEagle for an exclusive 60% off discount. Now, these data brokers are the reason why in the United States, you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It might also be why you're getting so many spam calls lately and even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and in that time, you can see that I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if your data broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. You can click on the link that's on screen or down below to try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court.